Thank you for being here for the hearing entitled Ending Illegal DEI Discrimination and Preferences, Enforcing Our Civil Rights Laws. This is the third hearing of this Judiciary Committee's Subcommittee on the Constitution, which I chair alongside Ranking Member Peter Welsh from the great state of Vermont. I want to thank the witnesses who are here today from the Department of Justice for being accommodating, and the first hearing this Congress involving a Senate-confirmed member of the Department of Justice. Ranking Member Welsh requested back in April we hold a hearing with Assistant Attorney General Dillon just a couple weeks before or after she was confirmed. Now that she's passed the 100-day mark, I'm so grateful that she's agreed to come testify about her historic successes so far in the important work she's doing on today's topic. Let me begin with a hard but necessary truth. For at least the last decade, America's civil rights laws have been used not to prohibit discrimination, but to institutionalize it. The modern civil rights regime, both inside and outside of government, has been wielded like a weapon, not to safeguard the equal rights of all citizens, but to engineer a radical new social order built upon the deliberate dispossession of huge swaths of our country. Rather than protecting the constitutional order of the founders, it has become the vanguard of a revolution in the political, legal, social, and even moral underpinnings of American society. The revolution has gone by many names: affirmative action, anti-racism, social justice. Today, it most commonly is referred to as diversity, equity, and inclusion, or DEI. But whatever the name is, in every instance, it amounts to the same thing: a new racial caste system sanctioned and enforced by the administrative state. Americans never voted for any of this. It slunk in through the back door, cloaked in bureaucratic doublespeak and soothing euphemisms. But today, it has wrapped itself around all the great institutions of American life: our schools, our businesses, our government, and even our armed forces. The bureaucracies of this new system are the diversity officers, the human rights commissioners, the HR managers, and select members of the groups at the top of the victim hierarchy. The victims are the rest of America, the smart, working-class kid who can't get a scholarship because of his skin color, the Christian business owner targeted and persecuted for his faith, the patriotic young West Point cadets subjected to mandatory struggle sessions for their toxic masculinity. DEI isn't just illegal, it's a fraudulent and cynical ideology, from top to bottom, built on layers of lies. It's not about diversity, it's about discrimination, a sustained campaign of collective punishment wrapped in the rhetoric of social justice. It's not about equity, it's about retribution. The advocates of DEI don't actually want to level the playing field. They aren't interested in equality under the law. Their entire mission is to elevate members of certain groups over members of other groups and remake America in their own image. And finally, it's not about inclusion. It's about exclusion of the competent, the qualified, the meritorious, when those people are members of the wrong race or sex. Over the course of the past few decades, these poisonous and illegal doctrines have transformed our institutions. In our universities, DEI has meant the abolishment of merit. It has meant the open, proud rejection of excellence and achievement in favor of racial quotas. Even now, after the Supreme Court ruled that race-based admissions are illegal in Students for Fair Admissions versus Harvard, the universities continue to flout the law, rebranding their quotas, cloak them in essay prompts and hiring practices and policies, but keeping the racial spoils system intact. At Harvard, at Princeton, at Stanford, the share of unrepresented minority groups did not meaningfully change after the Supreme Court's ruling, and in some cases increased despite huge disparities in test scores and academic preparation. Just earlier today, DEI administrators at the University of Tennessee and Vanderbilt were recorded gleefully discussing how they sidestepped DEI crackdowns by simply rebranding these initiatives. In the corporate world, DEI has had the same effect. It has meant hiring and promotion not on the basis of competence, but on the basis of race and sex. A world where one's place in the new caste system determines who rises and who falls. It has meant diversity fellowships that offer double pay, which white men need not apply. The effect of these policies has been even more extreme than many might guess. In the year after the Black Lives Matter protest, Bloomberg reported, the S&P 100 added more than 300,000 jobs. 94% went to people of color. 94%. In many blue states, DEI is now entrenched at every level of government decision-making. At the federal level, it has produced a vast universe of civil service preferences, taxpayer-funded minority-only grants, and open racial discrimination in contracting. Under the Biden administration, farmers in the Midwest were told they couldn't get debt relief. Restaurants were deemed ineligible for small business grants, and small business owners were barred from lucrative federal contracts, all for the crime of being too male or too white. Much of this took place in the wake of COVID, where years of rolling lockdowns decimated many small businesses and drove countless others to the brink. In the face of all that, the Biden administration redistributed billions of dollars from taxpayers to members of what they deemed to be socially disadvantaged groups, while leaving the rest of America out in the cold. The rest of America, to be clear, refers to the majority of people in this country, our fellow citizens, brothers, sisters, mothers and fathers, business owners and shift workers, good people who live honestly, work hard, pay their taxes, and expect only a basic standard of fairness from their government in return. Americans didn't vote for this. Instead, they voted for the 14th Amendment and our numerous civil rights laws that mandate equal protection under the law, not remedial power and monetary redistribution. Let me be even more clear. The only just and legitimate interpretation of our civil rights laws is what their text plainly demands: equal treatment under the law. That means an end to racial preferences, an end to double standards, an end to legal fictions like disparate impact, which treats differences in group outcomes as evidence of group discrimination, a totalitarian logic that demands a total leveling of society to achieve its ends. Ensuring perfectly equal outcomes between groups across race, sex, and every other protected characteristic would require a level of Marxist social engineering that would make Stalinist Russia look like a libertarian paradise, and it would still fail. Our civil rights laws and Reconstruction amendments were created to end a racial caste system, not perpetuate it. We must be based on the plain and unambiguous language and the meaning of the text to dismantle a system to restore equal treatment under the law. That means prosecuting illegal racial preferences and quotas wherever they exist, in colleges, in boardrooms, in state bureaucracies, and in the offices of the federal government itself. It means demanding that every entity receiving federal funds comply to the letter with the mandates of the law. Under President Trump, the Department of Justice is finally doing just that. Under the leadership of people like Harmeet Dillon, who's here today, this Justice Department has moved boldly to reassert the principle that civil rights belong to all American citizens, not just a select and favored few. The entire Trump administration has embarked on a shock and awe offensive against the DEI infrastructure. In just the first 6 months, they have launched a major civil rights investigation in the University of California system for its race and sex-based hiring practices and quotas. They opened active investigations into 45 universities, including Ivy League schools like Harvard and Columbia, for using illegal racial preferences in student fellowships, academic programs, and admission practices. They ended the doctrine of disparate impact in federal enforcement of civil rights law. They revoked decades-old executive orders that had embedded affirmative action into the DNA of the federal government and terminated all DEI positions and offices across the federal bureaucracy. They filed a major court challenge to discriminatory federal programs that had excluded thousands of workers and small businesses from hundreds of billions of dollars in government contracts. They launched a civil rights investigation into the Harvard Law Review for discriminating on the basis of race in article and editorial board selection, and threatened to strip the accreditation of Harvard and Columbia if they failed to comply with federal civil rights law. They began pursuing Title VII enforcement actions against law firms that openly advertised diversity fellowships for which white men could not apply, programs that are plainly illegal under federal law. These actions are just the beginning, but they represent, at long last, an attempt by the American government to apply our civil rights laws as they were actually written. For too long, we allowed the civil rights apparatus to be weaponized against the very rights it was supposed to protect. For too long, the people who ran our government looked the other way, or worse, actively partnered with those who were engaged in outright racial discrimination. Those days are over. Today's hearing is about reaffirming a simple but radical truth, that all Americans are entitled to equal protection of our laws, and that no Americans should be treated as second-class citizens in their own country. As Chief Justice Roberts so eloquently put it, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. The same goes for every protected class under our civil rights laws. The Trump administration has done extraordinary work in beginning the long, difficult task of restoring this principle in the conduct of our government. This subcommittee is going to do the necessary work to ensure we do everything in our power to finish that job. With that, I'd like to thank our witnesses for being here. I look forward to your testimony and turn it over to my friend Peter Welsh from the great state of Vermont.
Thank you very much, Mr. Chairman. I really appreciate you calling this hearing. The questions before us are absolutely profound. They're being tested and litigated, and they're being contested politically. The question before this Congress is whether we're going to save the Civil Rights Division or we're going to destroy it. And I want to step back just a moment. The Civil Rights Division is a crown jewel in the Department of Justice of the United States of America. It was founded in 1957. It was founded by a Republican president, Dwight D. Eisenhower. It was when we were beginning to come out of the dark days of legalized discrimination, the Jim Crow laws in the South, lynchings, denial of voting rights, discrimination in housing. The Congress began slowly to address this with laws. The Civil Rights Division in the Department of Justice, in a very turbulent time, had the responsibility to enforce the laws of the Congress that were passed by Congress, not the prerogatives of the president. And it did extraordinary work then, as it is doing now. They investigated assassinations of Martin Luther King, Medgar Evers. They brought landmark cases to desegregate school districts in the South against bitter opposition to allow the decision that separate and equal would not stand. It also took the lead in making voting a reality for folks who couldn't vote. You know, Mr. Chairman, I began my career in, I guess it's in politics, because of the civil rights era. I went to Chicago and was a community organizer, and I was shocked as a young man to see that black folks in the west side of Chicago, in Lawndale, who had two jobs, who were struggling to pay their bills, who were looking to make their schools better, they couldn't buy a house and get a mortgage. It was legal for the banks to deny them a mortgage. It was legal for the Veteran Affairs Department to deny folks who served as soldiers in World War II to get a VA guarantee. It was legal under the Illinois law to evict folks who were paying on contract to buy a home. But if they missed a payment after 10 years because somebody got sick or you got laid off from your job, legally, they could have their entire house taken back and have no equity. And it was Civil Rights Division folks who were in there fighting for the rights of those Americans. That battle continues. And that's what we're going to be testifying about today. But the most important thing that we have to remember is that there was a congressional responsibility to establish laws about what rights individuals had, regardless of their race, their gender, their sexual orientation. And those were the laws that were enforced by the Department of Justice through the Civil Rights Division. And I am so indebted to those lawyers who made a decision, oftentimes to say no to a career on Wall Street or K Street or Market Street in San Francisco, and to be here in the Justice Department to advocate and represent the rights of citizens as those were defined by the Congress of the United States. It's a new day. And our witness here is going to testify. I look forward to hearing what her testimony is. But there's a profound difference in the Justice Department today than there was the day before the election. And that is the new policy directives that are being issued to DOJ attorneys is the zealous and faithful pursuit of, quote, the priorities of the president. No, it's the priorities of the Constitution. It's the priorities of the legislation passed by Congress. It is not the priorities of any person, even if that person is the President of the United States. That is not what the job of the Justice Department is to do. So today, Mr. Chairman, I so appreciate your statement. You're engaging this issue, but I'm going to have to say we're going to have some disagreement along the way.
That's right.
Thank you. I yield back.
That's all right. That's America, right?
Yeah.
I'll introduce our witness. Ms. Harmeet Dillon is the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. She was nominated by President Donald Trump in December of 2024. She was confirmed by the U.S. Senate on April 3rd, 2025, and sworn in by Attorney General Pam Bondi on April 7th, 2025. Prior to joining the division, Ms. Dillon founded both the Dillon Law Group, Inc., a successful legal practice with offices in California, Florida, Virginia, and New Jersey, and the Center for American Liberty, a nonprofit organization dedicated to pursuing civil liberties legal claims. Her law practice focused on the First Amendment, free speech, civil rights, and campaign and election law issues. Among her many notable cases, Ms. Dillon brought legal challenges against the University of California, Berkeley over its free speech policy, against an Antifa organization for an assault on a conservative journalist, against several states for their restrictive responses to COVID-19, and against various large tech companies for a host of civil rights issues. Assistant Attorney General Dillon was born in India and lived in London before moving to the Bronx, New York. Her family ultimately settled in rural Smithfield, North Carolina. After graduating high school at the age of 16, Ms. Dillon attended Dartmouth College, where she became editor-in-chief of the Dartmouth Review. After earning her bachelor's degree in classical studies, she attended the University of Virginia School of Law and served on the editorial board of the Virginia Law Review. She later clerked for the Honorable Paul Niemeyer of the Court of Appeals for the Fourth Circuit. Ms. Dillon, it's the tradition of this committee to swear in all witnesses who testify before it. Would you please stand and raise your right hand? Do you swear that the testimony you're about to give to this committee is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Thank you, Ms. Dillon. Give your opening statement.
Good afternoon.
Good afternoon, Chairman Schmidt, Ranking Member Welch, and other distinguished members of the subcommittee. I am honored to testify on ending illegal racial discrimination and preferences through vigorous enforcement of our federal civil rights laws. I look forward to working with all of you to ensure that we successfully dismantle all forms of invidious racial discrimination from our society. On January 21st, President Trump signed Executive Order 14173, titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. The executive order stated that race and sex-based preferences under the guise of so-called diversity, equity, and inclusion violate the text and spirit of our long-standing federal civil rights laws. DEI initiatives reflect a set of practices that unlawfully discriminate against, classify, exclude from participation, or deny benefits to individuals based on race, sex, or other prohibited characteristics. The order announced that it is the policy of the United States to protect the civil rights of all Americans against illegal DEI initiatives. Enforcement of that policy is now delegated to me. Just last week, I reached the milestone of my first 100 days in office, and under the leadership of Attorney General Pam Bondi, we have been busy implementing President Trump's bold agenda for ending illegal DEI for all Americans. I will highlight some of our work for you today. Here are some of the ways we have taken steps to end DEI in education. First, as a result of multifaceted investigations into illegal DEI-based discrimination, harassment, and abuse at major so-called elite universities and colleges, the division is now in discussions with many educational institutions to end all unlawful DEI programs throughout these schools, including in their law, medical, nursing, and other specialty disciplines. Second, we are actively investigating several prominent colleges and universities regarding rampant anti-Semitism, resulting in discussions aimed at ending anti-Semitic abuse on college campuses nationwide. Third, starting in April, we open investigations into 50 major universities, 16 top law schools, and 7 medical schools by sending letters requesting any changes to admissions processes post Students for Fair Admissions versus Harvard. We are also investigating racially discriminatory admissions practices at selective public high schools. Fourth, we are engaged in several lawsuits and investigations into Title IX discrimination against the rights and safety of women and girls in classrooms, athletic fields, dormitories, and other facilities. As a result of our efforts, several institutions have reversed course already. Fifth, we are investigating the University of California for its race and sex-based discriminatory hiring practices under UC's 2030 capacity plan. The Civil Rights Division has also acted in various employment-related matters. First, we are investigating Minnesota's hiring and employment practices. State policies appear to require agencies to engage in illegal race and sex-based hiring in violation of Title VII. Second, we are investigating the Hennepin County Attorney's Office policy that requires race-based decision-making in plea agreements. The investigation is ongoing, though that office has refused to cooperate with our investigation. Third, we're investigating Rhode Island regarding its affirmative action plan that sets race-based hiring goals across its government. In light of Rhode Island's refusal to cooperate, we're assessing our next steps under Title VII. Fourth, we're investigating Chicago's racially discriminatory hiring practices permeating its government. This is just a small fraction of the extensive portfolio of actions we have taken toward ending DEI in my first 100 days in office. Every day, my team assesses new opportunities to combat invidious racial discrimination, from diligently pursuing investigations to drafting and filing federal civil rights lawsuits. The Civil Rights Division strives to protect the civil rights of all Americans against illegal DEI initiatives. In his famous dissent in Plessy versus Ferguson, Justice John Marshall Harlan wrote that the law regards man as man and takes no account of his surrounding or of his color when his civil rights are guaranteed by the supreme law of the land are involved. Nearly 130 years later, Justice Ketanji Brown Jackson echoed this sentiment in Ames versus Ohio Department of Youth Services, writing that the Civil Rights Act prohibits discrimination against any individual because of such individual's race, color, religion, sex, or national origin. While the division's jurisdiction is governed by statute, we work closely with the chair of the EEOC and heads of other executive branch agencies to combat illegal DEI initiatives and to uphold the civil rights of all Americans. With these efforts underway, Senators, the goal is clear. Either DEI will end on its own, or we will kill it. I look forward to exploring ways to bolster the division's enforcement authority so that we can completely root out discrimination in all its forms. Thank you.
Thank you, Ms. Dillon. I want to get to, in my time for question, get to 3 questions. The first is about your priorities. Second one's about rebranding of DEI that we're starting to see, and then how you see it in the corporate sector as well. So I want to give you an additional opportunity to sort of amplify. How are you with this mission of ending racial discrimination? What are sort of your priorities across the sectors and making sure our civil rights laws are applied to protect individual rights?
Well, thank you for the question, Senator. It's a big job because, as you pointed out in your opening remarks, discrimination in the guise of DEI has permeated every level of our society. And so we are taking our guidance from the priorities of this administration and the obvious violations that are occurring, coupled with recent Supreme Court precedents that make our obligations clear. So with Students for Fair Admissions setting the way and making clear that the types of discrimination that our universities have engaged in for decades is illegal, that is a key focus because there are billions and billions of dollars. Some universities that we're investigating themselves receive over $1 billion a year in federal funding. And so our responsibility toward the taxpayers requires us to focus on those big ticket items, but we are also looking at offenders up and down the spectrum. In the employment field, similarly, you mentioned that there's a lot of discrimination happening in the big American corporations, but we're also seeing it throughout state and local governments. And again, we feel it is important for the economy and for the civil rights enforcement priorities to pursue those violations wherever we find them. And then, of course, I have a large portfolio beyond the DEI issues, and so we do our best with the various resources that we have.
You got a busy job. I want to, sort of the DEI now, I think the public has been educated to a much larger degree than it was, say, 5 years ago about what that really means beyond just sort of flowery language. But there is an effort now with some of these DEI programs to kind of use other vague terms to cloak the very divisive and discriminatory policies, whether it's community and belonging initiatives, and they relocate their staff in other ways that aren't called DEI officers anymore. What are you doing, or how are you identifying this, and then how would you approach addressing that as well? Because it's the same thing.
Well, Senator, when I hear the words or the slogan DEI, what I hear is discrimination, exclusion, and intolerance. And that's what we're seeing throughout all of these programs nationally. Now, we are relying on the public and whistleblowers throughout these organizations to let us know when this type of fake rebranding is occurring, and yet the same personnel and the same policies are continuing to perpetuate illegal discrimination on American citizens. And we are taking action. We are opening up investigations. Sometimes simply opening an investigation results in the individuals who are blatantly flouting our federal civil rights laws being terminated or reassigned or otherwise. And so we are seeing these actions take place throughout the United States. And I'm pleased to say that in response to several of the letters that I sent to open up federal civil rights investigations, many schools are stepping forward and voluntarily providing us with the data requested and showing that indeed they are honoring and following Students for Fair Admissions and other federal civil rights laws.
So as your division, your department gets back to sort of enforcing the plain language of the statute, there are also violations that exist in the corporate world, whether it's edicts from CEOs or the boardrooms or HR lawyers that are seeking to discriminate by another term. What are you guys doing? Are you relying on whistleblowers there? What can you share with us about how you're taking? I mean, this is predominant in big law. I mean, they don't even try to hide it. But what are you doing to identify that and pursue those as well?
Well, Senator, the primary jurisdiction for private employment violations rests with the EEOC, and I have almost daily conversations with the chair there. Many of those investigations are confidential, and unfortunately I cannot share details of those. But what I will say is that in the instances in which many of these top corporations are also government contractors, for example, in the defense industry or the tech industries, the agencies that are hiring them or giving them grants also have jurisdiction to open up investigations. Those investigations are happening throughout the United States federal government. And when those investigations are concluded without satisfactory resolution or termination of the DEI policies in question, these matters are often referred to the Civil Rights Division for further enforcement. So we are just getting started after our first 100 days, but I can promise that throughout the tenure of this administration, there will be numerous investigations and lawsuits against institutions that continue to offend our federal civil rights laws.
That's good to hear. One final question. As this committee, jurisdiction and oversight, do you think it would be helpful if this committee were to subpoena or otherwise bring forward entities that might be in violation of this as well?
Unequivocally, yes, Senator.
Thank you. Okay. Well, it sounds like a plan. Senator Welch.
Thank you very much. Ms. Dillon, who won the 2020 election for president?
Senator, I previously testified on this matter. President Biden was declared the winner of that election, and I honor that and respect that.
So, but you can't say he won.
I mean, he was the president for 4 years. He clearly was the president.
Most of us know that. I'm asking if he won,
I've answered your question, Senator.
but you haven't. I want to ask you a question about Texas redistricting. As you know, President Trump has recently encouraged, I'll use that, Texas Republicans to do mid-cycle redistricting in order to gain more seats in the House of Representatives. I understand that after the president made that decision or that announcement, you personally sent a letter on July 7 to Texas in your capacity as Assistant Attorney General, arguing that 4 Democratic districts violate federal law. Is that the case?
It is the case that I sent a letter under my authority to administer the Voting Rights Act and indicate that in light of our analysis of 4 so-called coalition districts in Texas, that those districts were inconsistent with the Voting Rights Act.
And the date of July 7 was just coincidental, that it occurred after the president had called on the Texas legislature to do mid-decade redistricting?
I don't remember what date, Senator. I probably sent 300 letters since I've been in this office. And so what I can say is that I send no letter or make no request without proper investigation.
Have you sent any other state legislature a letter where you have indicated that districts within their state are in violation of federal law?
Not yet.
More redistricting to come?
I don't know. I have to investigate the facts.
Before you sent the letter on July 7, did you have any conversation with any representatives of the White House?
Senator, as you're aware, there are privileges that are involved in all executive branch communications, and I'm not able to testify without breaching the Department of Justice's guidelines in that regard, so I'm unable to answer any questions about conversations I may have had with other executive branch officials.
I'm not asking you what the content of the conversation was. I'm asking whether there was any conversation with anyone from the White House before you sent that July 7 letter.
Senator, I have the same answer. I think you're aware of the broad scope of privileges that apply to lawyers' conduct.
Well, here's what I'm aware of. The president made a directive, which is highly unusual, telling a legislature, the Texas legislature, mid-decade to do redistricting, when we do that every 10 years. And it just so happened that the Assistant Attorney General sent a letter to that legislature after the president made his announcement and said that your investigations suggest 4 districts are in violation of federal law.
Is there a question, Senator?
There's a point here that it's hard to believe that that wasn't coordinated.
Well, let me draw your attention to a different fact that refutes your argument, namely the governor of the state that I called home for 25 years also called for redistricting in the state of California, and I haven't sent a letter to California. So correlation is not causation, Senator.
Which 4 districts did you say are in violation?
I did not come here to testify about that, but if you wish to have a follow-up with me about it, I'm happy to pull up my research. I'm not...
Would I be surprised that those were Democratic districts?
I don't know how to answer that, Senator. I'm not here to testify about that. I'm sure it's convenient to try to distract from the purpose of this hearing, which is to talk about DEI, but that is not what I'm prepared to testify about here today, Senator.
You have put a freeze on activities that the Justice Department in your division had done before, and you have walked out of settlements. I'm going to talk about Lowndes County in Alabama.
Senator, I think you're misinformed. There was a temporary freeze prior to my taking office. There's no freeze on activities. I filed numerous lawsuits, opened dozens and dozens of investigations, entered into numerous settlements, opened hate crime investigations involving numerous religious backgrounds. So I don't know what you're talking about, Senator.
Well, I don't have that much time, so we'll have to take this up in the second round of questioning. So I yield back. My time is up.
Thank you. Before we get to Senator Lee, it's worth pointing out that Texas's current congressional map was drawn to comply with the now overturned Fifth Circuit holding. If Texas doesn't redraw the line, it's probable that their current map will be found invalid under the Peatway decision. Senator Lee.
Thank you, Mr. Chairman. Thank you, Ms. Dillon, for being here today. We have, over the course of time in our country, seen that a lot of people have worked really hard for a long time to try to divide our nation along racial lines. Now, history may not repeat itself, but it often rhymes. In nearly every era of American history, people who have done this, perhaps sensing deep down that this is wrong, that it's just fundamentally wrong, try to justify it. And almost invariably, they will couch it in terms of this is better for everyone, in terms that make it sound charitable, kind, it's for everyone's good. That was the case, for example, in Brown versus Board of Education. The defendants in that case, defending their own pattern of de jure racial discrimination, said it's okay because our subjective motivation for doing this is benevolent. It's not malicious. We think this is best for the educational experience. And yet it's wrong. And yet it's also contrary to the direct terms of the Equal Protection Clause of the 14th Amendment, and since then it's been made doubly illegal. It's been made in violation of a number of federal civil rights laws. Now, one of many more recent modern examples of this attempt to divide American citizens on the basis of race involves the use of disparate impact policies, policies that in many circumstances effectively encourage racial hiring quotas and erode equal opportunity of employment. When you're doing that, you're violating the law, it would seem to me, because you're treating people differently on the basis of race. And that is something that Title VII in the employment context prohibits. It's why I introduced a bill called the Restoring Equal Opportunity Act to codify President Trump's executive order banning the use of these disparate impact programs that themselves end up imposing de facto racial hiring quotas. So how, in your view, has this concept of disparate impact and the use of disparate impact policies undermined equal opportunity in hiring?
Senator, what we've seen, and I've been a civil rights lawyer for over 3 decades now, is that the well-meaning quota-based systems that you described have resulted not in equal opportunity for individuals, but sort of a group form of justice that is more of a Marxist concept, and it is frankly inconsistent with our Enlightenment-inspired constitutional values that guarantee equal opportunity for every individual. And so I think that is really the philosophical difference. If you believe in equality or equity-based outcomes as opposed to individual rights and opportunity, that is where the distinction falls. And our civil rights laws are clear. And as recently as this year, since I've been in office, in the Ames case, the United States Supreme Court has reiterated that every individual is entitled to equal consideration under the law under Title VII, and not simply have a higher burden of proof because they happen to be a majority plaintiff.
Right, and people in that circumstance can make determinations, hiring determinations, for example, on the basis of a whole range of criteria. But there are some criteria that are inappropriate, and race is perhaps chief among them. What are some examples that you have seen of employers or of universities misusing race-neutral civil rights laws in order to justify discrimination?
Well, Senator, you see so many examples of racially exclusive scholarships. You see hiring opportunities or programs in both faculty as well as other staff that require a quote-unquote racially diverse pool at every step of the hiring process that effectively at multiple levels excludes qualified individuals from being able to qualify and compete and get to the end of that process. But you even see today, after all of these civil rights laws and all these Supreme Court precedents, blatantly racist ads from some of these institutions of higher learning soliciting input from so-called disadvantaged minority groups, and these are illegal. I mean, you're also seeing in response to Students for Fair Admissions and other cases, video requirements in applications now that bring back the racist attach your photograph to your job application, which allows racial discrimination. So that's something that we need to look at eliminating as well, Senator.
In the context of law firms specifically, well, law firms are one category of employer that you would expect to be especially aware of developments in the law. What have you seen from among law firms in terms of their willingness to follow federal civil rights laws as they've been interpreted and clarified in recent years by the Supreme Court?
Well, Senator, I left the big law sphere over 2 decades ago because of, frankly, odious and persistent racial discrimination that permeated those institutions, and it's not better today than it was back then. But this is also perpetuated by employers and, big pension funds that require racist gerrymandering, if you will, of the staff that service them at these law firms. So we really have to change these practices throughout. And, the EEOC is tackling discrimination at law firms. I think it's going to be a long haul, but I think ultimately with persistence, we'll be able to level that playing field, Senator.
My time's expired, but it sounds like you don't disagree with the assertion that benevolent motives don't negate the violation of the law at issue.
I would agree, and so would so would the justices of the Supreme Court.
Senator Schiff.
Thank you, Chairman. Ms. Dillon, you recently announced that DOJ was launching an investigation into the University of California over its UC 2030 capacity plan, which notes that future growth of faculty and students should result in campus populations that better reflect and tap the talent of underrepresented populations who represent the majority of Californians. In the SFFA versus Harvard opinion, the Supreme Court held that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise, allowing universities to continue assessing students' experience with race on an individualized basis. In that opinion, in his concurrence, Justice Thomas praised the University of California for achieving diversity through race-neutral policies, including preferences for low-income applicants and first-generation students, and recruiting efforts targeted at areas with substantial populations of people of color. Are the race-neutral policies like those used by University of California, which Justice Thomas explicitly praised in that opinion, now considered by you to be illegal DEI?
Well, Senator, first of all, the investigation that we've opened is an investigation, and it's an investigation into the hiring policies of the University of California system, not the admissions policies. That said, I have absolutely seen abuses in the admissions policies in using race as a crude proxy for discrimination. That's not the question I asked you.
Are the race-neutral policies praised by Justice Thomas now considered by you to be illegal DEI?
I think you're mixing apples and oranges. So I can't really answer your question.
You can answer my question and say, yes, they are now illegal. That is what Justice Thomas praised in terms of race-neutral policies, which include preferences for low-income applicants, first-generation students, things like that. Are you now saying that what Justice Thomas praised is now illegal in your view?
Senator, there's a difference between what you see on paper and what you see in reality, and I reject your premise. I reject your premise that how California describes its admissions practices is
about whether you subscribe to the Supreme Court's opinion or whether you disagree with Justice Thomas' concurrence. You can answer that question, can't you?
In the abstract, yes. In reality, what you're describing does not exist in the UC system.
Okay, so Justice Thomas got it wrong. Is that what you're saying?
I'm not saying that.
Well, you are saying that because he was praising the policies of the University of California. You seem to be saying now that any university that gives a preference to low-income applicants is engaged in illegal DEI, or if they put a focus on first-generation students, that's somehow impermissible. After all the years of criticism of cancel culture, you seem to want to cancel any institution that has views that you disagree with. In answer to the questions about law firms, you want to cancel law firms because they take on unpopular clients to you, to the administration. That is, if a firm represents someone with an adverse interest to the administration, which is their First Amendment right to do, and I would also say their duty to do, you would cancel them. You would cancel universities like Harvard or the University of Virginia that take positions and exercise their First Amendment rights contrary to what you think the administration wants to see. You would cancel the Associated Press for not using the ridiculous nomenclature of the Gulf of America. You're canceling now the Wall Street Journal because the Wall Street Journal had the audacity to publish an article about Trump's connections to Jeffrey Epstein. So this is what's going on in this administration. You've devastated the Civil Rights Division. Hundreds of attorneys, 368, have departed since January of this year. There's been a mass exodus from the Civil Rights Department. It is just a shell of what it used to be. They're being canceled. They're being canceled by you, by the department. Anyone that stands up to this president is at risk of being canceled. And I think what you're doing to use the sledgehammer of federal funding with universities to try to coerce them to accepting your right-wing agenda is disgraceful. And using that cudgel will have far-reaching implications, attacking research done by universities, academic independence done by universities. It will establish a dangerous precedent that can be abused by a president of any party, and we should recognize that on a bipartisan basis, even though it does not appear that we do. I yield back, Mr. Chairman.
Thank you. Senator Kennedy.
Thank you, Mr. Chairman. General, how are you?
I'm well, sir. Thank you.
Good. General, you believe in diversity, don't you?
I do, sir, yes.
Yeah. And if I defined equity as a state of fairness and impartiality, you believe in equity, don't you?
Well, equity is a proxy for discrimination, unfortunately. In these
I know,
policies,
but I'm not talking about the proxy. If I define it as a state of fairness and impartiality.
Those are very important virtues, yes, sir.
Yeah, I certainly agree with equity. And I watched it through your confirmation here. You strike me as an inclusive person as opposed to exclusive. You seem to like people.
I like to think so, sir.
So you believe in diversity, equity, inclusion, as most normal people understand those terms. But that's not what we're talking about here, is it?
And no, it isn't.
Diversity, equity, and inclusion, as many institutions and people in America like to use it, are talking about quotas, aren't they?
Yes, unfortunately, quotas have become the proxy for that vaunted slogan.
So when someone says diversity, equity, inclusion, we're talking about quotas. Let's be honest.
Quotas and discrimination.
Do you think, let's just take race. You can discriminate on any number of things, and you shouldn't discriminate on any of them, not on illegitimate characteristic, but let's just take race. Do you think race should be used to harm a person?
It's illegal to use race either to affirmatively try to help or discriminate against an individual.
It's wrong to use race to harm somebody.
Yes, sir.
It's wrong to harm somebody because of their race.
It's illegal and un-American.
Yeah, it's okay to harm them legally and appropriately because they're an a-hole, but not because of their race, right?
Yes, sir.
Now, it's also wrong and illegal to help somebody because of their race.
That is correct.
I mean, that's illegal, right?
Under our Supreme Court precedents and our laws, that is correct.
Okay. But we still have institutions, even after the Supreme Court's opinion, we still have institutions in America, some in government, certainly some in the private sector. I'm thinking of some of our universities who insist on implementing quotas. And that's what you're going after, as I understand
I'm
it. Am I right?
aggressively seeking to end those quotas. They're illegal and un-American.
Okay. And that's really what we're talking about, is quotas. And the American people don't support quotas. They just don't. I mean, I think most Americans don't think about race as much as people in Washington, D.C. do. The American people they understand that souls don't have a color. They believe that to a bear, all of us taste the same, like chicken. So this obsession now with diversity, equity, and inclusion, it's not really, I mean, it's a pretty phrase, but it's not diversity. Who's against diversity? That's like being against golden retrievers. Who's against equity? Who's against inclusion? So they pretty it up, but they're really talking about quotas. And it's illegal. And it's immoral. And it's un-American. And it exists. And I'm watching it happen in our universities. You know, I mean, Harvard, I wish it weren't the case. Incredible university, really bright people, but it's clear they believe in diversity and equity and inclusion and the right to hurt Jewish people. What did we come to? Any closing comments? I said too much.
No, Senator, I agree with you, and I will say that the whole of this government is dedicated towards providing equal opportunity for all Americans. And anti-Semitism on our campuses is a shocking problem, but we've actually made great progress just in these first 100 days on that front. So thank you for your attention to these issues.
General, don't let the bastards get you down, okay?
Thank you.
Senator Hawley.
I'll yield to Senator Blackburn.
Senator Blackburn.
All right, Senator Hawley, thank you. And thank you so much for being here with us. DOJ and your department are doing such important work to root out anti-Semitism, to root out DEI. And I think in that process, you are doing an admirable job educating people on what has been going on in this country, and I appreciate that and the way you've drawn attention to what has happened on our nation's campuses and trying to divide people on racial and ideological lines. I appreciate what you have done there, and I know President Trump has said many times, bringing this country together, uniting this country is something that is very important to him. And in Tennessee, we've got some great universities. They do wonderful research work. They do great workforce development work, and they're doing all they can to be certain that we remain competitive on the global stage. And while I appreciate the efforts that they are making to adhere with not only our state laws, but with the president's directives and his executive orders, and to root out these DEI initiatives, they are still having to deal with a few woke activists that are within their ranks. And just today, yesterday and again this morning, there were videos released from 3 Tennessee universities. And I have talked with 2 of those university presidents, and we've discussed the work that they are doing. But within their ranks, some of these professors that are so given to DEI will not let it go. And so they take other programs and they're telling people, well, this is how we're getting to DEI. This is how we're covering it up. This is how we're using language to form workarounds. And I think that one of the things this has shown me, looking at all this video footage the past couple of days, is how deeply rooted the left is in this DEI effort and how they are trying to manipulate today and to keep hold of that DEI effort. They will not let it go. So as you are working with these universities that say they're trying to comply, that are hiring outside auditors to come in, how do you work with them and help them root out these activists and change the way these activists are trying to influence the students? What can you do there?
Well, thank you, Senator. The way we're starting with the first tier of universities that we have requested data from is requesting data. And so we are beginning to receive thousands and thousands of pages, and we have data crunchers in the DOJ who are helping us analyze the data. But we're also relying on whistleblowers like the ones you just referenced in the Vanderbilt and the other schools that are engaging in this behavior, and they're helping us expose the defiance of federal law. And, it's very interesting. I've heard a lot of lofty phrases here, but this is not unusual compared to what we saw in the Brown v. Board of Education era. A decree came down from the Supreme Court that separate but equal was illegal, and yet throughout the United States, particularly in the South, where I grew up too, we saw government officials openly defying those orders by rebranding and using different methods, and it took decades to root that out. I hope it won't take decades to root this out, but we see similar defiance like we saw with the Dixiecrats today in American institutions. And I went to University of Virginia Law School. They have done the same thing that you're describing as rebranding and simply saying that we're going to keep doing things, use a shell game, and confuse the government. We are not confused. We will get to it. And I think the biggest hammer that's going to cause change is the United States policy to simply stop wasting American taxpayer dollars and sending them to institutions that openly and blatantly violate federal law. And we are doing that throughout the government. I'm proud to be part of that effort, and we are very vigilant and will not rest until we have completely eliminated these discriminatory policies in our institutions of higher learning that receive federal funding, Senator.
Right. One thing I wanted to touch on, and I'm running out of time, when you went through your confirmation, I talked to you about election integrity, and I know you're doing some work on that. So, Mr. Chairman, I would like just if she can respond briefly on the election integrity issue.
Senator, we at the Civil Rights Division enforce the Voting Rights Act, the Help America Vote Act, and the National Voter Registration Act. And on each of these fronts, we are active. We are opening investigations. We are seeking information from states. Numerous states have received requests regarding their list maintenance requirements and failures thereof, their non-compliance with the Motor Voter Law, National Voter Registration Act, and of course, reference has already been made in this hearing to discriminatory coalition districts that are out of compliance with the Voting Rights Act, and there'll be much more to come as we work our way through inquiries, facts, petitions from governments, and so forth.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator. Senator Hawley.
Thank you, Mr. Chairman. Ms. Dillon, good to see you. You're doing a great job. Thanks for being here. I want to ask you about discrimination of a somewhat different kind. That's discrimination on the basis of religion. In the last administration, I'm sure you remember, the FBI issued a memorandum in which it attempted to recruit informants, spies, into Catholic parishes and probably, frankly, other Christian churches on the basis of these churches' theology. They designated and they created a list, an actual list. The United States government created a list of Catholic parishes and groups it did not like, branded them as traditionalist Catholics. I guess that's now a slur, and tried to recruit spies into these churches, which is unbelievable to me. I mean, you want to talk about a violation of one's civil rights. To my knowledge, that memo has never been formally withdrawn. The Attorney General of the United States at the time, Merrick Garland, sat where you're sitting, first denied it, then attempted to defend it. It is, in fact, totally indefensible. My question to you is, what can be done about discrimination like this by our own governmental institutions? I think one of the things people voted for in electing the current president, who I was proud to support, is they voted to put a stop to that kind of discrimination, to that kind of abuse of our own citizens by our own government. And I just submit to you, of all the abuses of the Biden era, and there were a lot, there's nothing lower than trying to recruit spies into churches to inform on your countrymen because you don't like what's being preached from the pulpit? I mean, this is insane stuff, and they were using the FBI to do it. Can something be done about this to hold accountable the people within the DOJ and the FBI who perpetrated what I frankly think are crimes? I mean, what can we do about this?
Well, Senator, first, I want to assure you that the policy that you just described would appear to be a dead letter today. We are certainly not doing anything of that nature in the Civil Rights Division or, to my knowledge, throughout the United States Department of Justice. Good. To the contrary, I would say, and I've been a civil liberties lawyer in favor of religious liberties for over 3 decades, this is the most religion-friendly Department of Justice in United States history. In the Civil Rights Division so far, we have taken action to side with a Catholic coach in the Rolovich case who was fired for refusing to take the COVID vaccine. We intervened in a lawsuit in Washington State, also where Rolovich is from, to challenge that state's discrimination against Catholic clergy, enforcing and trying to pierce their priest penitent privilege. And that law was just enjoined this week by a federal judge in Washington State. We have opened up numerous, in just less than 100 days, Religious Land Use and Institutionalized Persons Act, majority for the Christian community, but also for Jewish, Muslim, Buddhist, and other faiths as well. And we have opened up investigations into anti-Semitism throughout the United States. And I have been told by Jewish leaders who sat in my conference room that they had similar conversations with my predecessor because this problem is not a new problem, unfortunately. It is a problem that has been going on for years. And while my predecessor kindly nodded and listened to their complaints, nothing happened. Things are happening in this administration, and our door is open to people of all faiths to come and tell us what is happening, zoning violations, discrimination. Certainly if the government is spying on them, that would be outrageous, and I would be interested to know names and dates, and we would begin an investigation into that, sir.
Yeah, thank you. That's exactly what I think we need to find out. I mean, we need names and dates. We need to know who authored that memo. And those people, their names need to be made public. And if they are still employed, God forbid, at the FBI or the Department of Justice, they need to be fired. I mean, I just think we need some accountability, don't you? I mean, I think if you look at what's happened in the last 4 years, you look at how religious rights were trampled upon. Let's not forget, during COVID, who was shut down? You remember, who was shut down during COVID? The churches, the synagogues. Who was open? Oh, well, the marijuana dispensaries, they were open. Democrat Party donors, all the corporations that gave the Democrat Party, they were all open. But churches closed, synagogues closed. And then to have our own FBI recruiting informants into our churches, it's outrageous. I think we need to know who wrote these memos, who approved them, where were they distributed, and I think people need to be fired for it. And then I think, if possible, they need to be prosecuted for it. Don't you think? I mean, don't you think it's time for some accountability? I think we've got to turn the page and do better, sure, but we've got to hold accountable the people who did this in the first instance, or they'll just do it again. Well, they'll just do it again.
Senator, I agree with you. I mean, I was privileged to win between my law firm and my nonprofit 3 cases at the United States Supreme Court during COVID to protect the rights of Christians to be able to pray in my state of California. And the governor is still the governor, and there has been no accountability in that state for the gross violations of every person's right of faith. And so I hope that voters ultimately hold the elected leaders accountable, but certainly people who grossly violated the First Amendment those are names I'd like to know, and we will look into that as a result of.
This is my last thing, Mr. Chairman, and I thank you for holding this hearing. I just think that you're right about voters, and voters did they voted for a change in November. They voted for accountability, and now we've got to give it to them. And I just want to, I know you're not in charge of the FBI, but I just want to send a clear message to everybody who is. There has got to be some accountability for what has happened with our government. There has got to be accountability for how it was abused. And religious believers were abused in the last 4 years, over and over and over. And we've talked about it, and we've held hearings on it, and now it's time to do something about it. And the people who perpetrated these outrageous abuses of our First Amendment rights, they need to be held accountable. They need to be held accountable, and they need to be held accountable as soon as possible. Thank you, Mr. Chairman.
Thank you, Ms. Dillon, for your testimony. We wish you all the best in the work and very important work that you're doing. Thanks for being here today.
Thank you, Senator.
We're going to swap out the nameplates and then have Mr. Hamilton and Mr. Stewart sworn in, and they'll have their opening statements and open for questions. Okay. Thank you both for being here. I know you just sat down, but I'm going to have you stand up. It's the tradition of this committee to swear in the witnesses. So if you'd stand and raise your right hand. Do you swear that the testimony you're about to give to this committee is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Okay, I'll introduce Mr. Hamilton, and then Senator Welch is going to introduce Mr. Stewart. Gene Hamilton is the president of America First Legal Foundation, a nonprofit legal organization he co-founded with Stephen Miller in 2021. Before serving as the president of AFL, he served as the deputy White House counsel in the Trump administration from January until June of 2025. Before serving as Deputy White House Counsel, Gene was Executive Director, Executive Vice President, and General Counsel of America First Legal before co-founding AFL in 2021. Gene served as counselor to the Attorney General of the United States Department of Justice from 2017 to 2021, senior counselor to the Secretary of Homeland Security, general counsel to Senator Jeff Sessions on the Senate Committee of the Judiciary, assistant chief counsel at the U.S. Immigration and Customs Enforcement, and attorney advisor in the Secretary Honors Program for the attorneys at the U.S. Department of Homeland Security, which included work in the Office of General Counsel's Operation and Enforcement Law Division, the Intelligence Law Division, U.S. Customs and Border Protection, and Transportation Security Administration. A lot of experience, I see. Gene graduated from Washington and Lee School of Law, magna cum laude, and Order of the Coif, and has a Bachelor of Arts in International Affairs from the University of Georgia. We'll have you want to introduce?
Sure.
And then we'll have you give your opening statement. Thanks.
Okay, thank you. Welcome. Senator Robert Stewart was born in Selma, Alabama, where public service and social justice were instilled at a very young age. He's a Democratic member of the Alabama State Senate, representing District 23. Elected in November 2022, you became the youngest senator in the Alabama legislature. Congratulations. And I understand professionally you serve as Chief Financial Officer of Foot Soldiers Park, a nonprofit dedicated to economic development, youth empowerment, and social justice based in Selma, Alabama. And a descendant of the historic Gee's Bend community, Stewart's family legacy includes his late maternal grandmother, who served as a nurse during the pivotal events of Bloody Sunday. Welcome, Senator Stewart.
Thank you, Senator Welch, and we'll have both of you, Mr. Hamilton first and then Senator Stewart, give your opening statements.
Thank you, Chairman Schmidt, Ranking Member Welch, and distinguished members of the Subcommittee on the Constitution. Thank you for allowing me to testify today about this critical issue. As President of America First Legal, advancing meritocracy, upholding the rule of law, and protecting the civil rights of all Americans is an important priority for our organization, and I appreciate the opportunity to talk about our ongoing efforts to fight discrimination in the United States of America. There is nothing righteous or even morally defensible about intentionally discriminating against American citizens, especially based on their race or their sex. What matters is whether a person is the best candidate for the job based on merit. Yet corporations, universities, K-12 schools, and other institutions that should know better have embraced intentional discrimination as though it were unquestionably their duty to do so. This was particularly true over the last 4 years under the Biden administration. Let me be clear. It is never acceptable. It is never okay for someone to hire, fire, promote, or take any employment action against an American citizen based on something like their skin color or sex. Balancing a workforce, for example, through race or sex-based preferences is never okay. Every reserved slot for one group necessarily excludes others. Attempting to address purported disparities through the use of such blunt instruments ignores intervening political, social, and economic forces like mass immigration and the erosion of the nuclear family, and it undermines the human dignity of every person subjected to such policies. Holding down one American under the purported premise of lifting up another is an abhorrent aggrandizement of bureaucratic power that threatens individual liberty and freedom at levels that would only be admired by committed socialists. No great nation can sustain the harm inflicted by such divisive policies. They undermine and weaken our great institutions, dilute our shared American identity, turn Americans against one another, and jeopardize the strength of the greatest country on earth. We are united by fairness, individual achievement, and equal opportunity, principles that have made us a beacon of hope and freedom and prosperity. But when government bureaucrats are empowered to pick winners and losers based on immutable characteristics, or when they encourage or conspire with or acquiesce to private actors doing the same, fractures form in the foundation of our great nation. Those fractures, which we see already, will continue to grow and ultimately destroy our constitutional republic if left unaddressed. Combating illegal DEI is vital to maintaining equal opportunity for every American and preserving our republic. Through our lawsuits and federal complaints, AFL has delivered concrete victories that demonstrate the power of resolute action. Although Congress has long outlawed discrimination via statutes like Title VI, Title VII, Title IX, 42 U.S.C. Section 1981, and also through using the actual Equal Protection Clause of the Constitution. Many entities persist in advancing DEI in blatant disregards for the statute's plain text and clear intent. Congress might explore further steps to refine or bolster these safeguards, like the Dismantled DEI Act. But the primary emphasis should be on ensuring individuals and entities face consequences for discriminating against American citizens via robust oversight, agency prosecution, and backing for private initiatives like America First Legal. I welcome your questions.
Thank you very much. Mr. Stewart.
Chairman Smith, Ranking Member Welch, distinguished members of the subcommittee, thank you for the opportunity to testify before you today. It is an honor and solemn responsibility to address this esteemed body during a time of great consequence for our nation and its ongoing commitment to equity, justice, and democracy. My name is Robert Stewart, and I'm a proud native and current resident of the historic Selma, Alabama. And I serve as the state senator for Alabama's 23rd Senate District, home to the storied counties of Lowndes, Dallas, Wilcox, Perry, Monroe, Butler, Clark, and Conecuh in the heart of the Alabama Black Belt. This testimony is rooted in the lived experiences of the people I represent, descendants of enslaved Americans, veterans of the civil rights struggle, and rural families who have not yet realized the full promise of the democracy they helped forge. I begin by invoking the words and legacy of President Lyndon B. Johnson, who declared a war on poverty during the height of the civil rights movement. Tragically, I come before you to declare that we have shifted from a war on poverty to a war on the poor. In the Alabama Black Belt, including Lowndes County, where citizens risk their lives to build a multiracial democracy, our communities are still fighting for the basic rights that define human dignity and American citizenship. These rights include clean water, functioning sewage, equitable education, livable wages, and the protection of civil liberties. Let us remember, it was the people of Lowndes County, Black farmers, teachers, and veterans who advanced the cause of American democracy by demanding not only the right to vote, but also protections against land theft, wage theft, state-sanctioned violence, and the right to self-determination. They understood that the ballot box alone could not uproot inequality without accompanying justice in housing, health, labor, and infrastructure. Today, the same region suffers from conditions that will shock the conscious. In 2017, a report by the United Nations revealed the presence of hookworm, a disease long considered eradicated in the developed world. Due to failing wastewater infrastructure in Lowndes County, families were exposed to raw sewage because septic tanks had collapsed and outdated policies left them without solutions. Thanks to the dedicated work of Congresswoman Sewell, President Joe Biden, Governor Kay Ivey, Alabama Department of Environmental Management, the Alabama Department of Public Health, and with the bipartisan efforts led by President Trump during his first term, investments were finally made in wastewater infrastructure across rural America. Yes, we are grateful for President Trump's efforts during his first term that led to the transformative progress. I commend Ms. Sherry Bradley and the Black Belt Unincorporated Wastewater Program, whose tireless efforts have connected hundreds of families across the Black Belt to working sewage in record time. But this momentum will stall without restored federal support. Here's a quote from Lowndes County resident Ms. Perman Hardy of Coleraine, Alabama, who lauded the program. "My children grew up using straight pipe. My grandchildren grew up using straight pipe, but my great-grands are now growing up with a working septic system, finally." We gather here to discuss civil rights and illegal discrimination, but let us not overlook the structural discrimination of neglect. DEI initiatives are not preference or perks. They are attempts to rectify generations of exclusion and ensure equal access to opportunity. To eliminate these efforts under the guise of enforcing civil rights is to misinterpret history and undermine justice. Thank you, and I welcome questions.
Thank you, Mr. Stewart, and thank you for being here. Mr. Hamilton, let me ask you, sort of following up on some of the questions that I asked Ms. Dillon and after her testimony, that a lot of these, discriminatory efforts, these divisive efforts couched as DEI, a lot of the, there's a lot more awareness now of what that really is. 5 years ago, maybe not so much. The flowery language sort of cloaked the discriminatory aim. Where do you see this headed now? There's still work to do there, and she's doing the work, and I think you'll probably see more other causes of action from individuals even probably pop up. But, whether it's social emotional learning or community, whatever the term might be, what are you seeing out there that is sort of DEI by another name?
That is a really good question, because we've seen in some cases corporations, universities, other institutions take on and actually abandon some of these exclusionary programs and policies. But in many other cases, they seem to be just deleting the language or changing the language and morphing to things, trying to fly under the radar long enough to think that they're going to evade federal enforcement, or they're going to evade private liability. And so what do I think is going to happen? Where do I see things going? I think I see with this Department of Justice, with organizations like mine and others, a renewed awareness and commitment through education, through litigation, through everything in between, to make Americans aware and to make corporate leaders, make the C-suite and the university administrators aware that discriminating against American citizens, whether you can call it any name you want, call it any kind of program, but any program that discriminates against an American citizen or reserves something for another citizen and provides a benefit, whether that's in terms of an employment, whether that's in terms of education access, whether that's in terms of anything of the sort, that is discriminatory and there is liability. There is actual liability that will attach to it. We're proud at America First Legal to represent many individuals who have had successful resolutions of their claims of this type of discrimination, whether in the private context, whether in the public context, everywhere in between. But what it's going to take is more attention, more spotlighting, just like you're doing with this particular hearing, to make the American people aware and to educate everyone of what Congress did when it passed the plain statute, Title VII, Title VI, again, Title IX. If you just return to the plain text, and we're all textualists these days, if you return to the plain text of those statutes, there is no discrimination that's permitted against an American citizen on those bases.
I want to talk, with the time, 2 minutes I've left, touch on sort of two topics that are somewhat related. And I think for a lot of people, like normal people out there that don't live in this like radical racialization of America that many of the elites and those on the left have pushed, they don't understand where this comes from. Corporations are supposed to, they hire people, they make money, but this sort of insidious corporate equality index that many of them chase, that sort of puts out there as this carrot, you're going to get a great rating and we're going to talk about how great you are. And it's funded by, that partially by Soros and all these groups that are chasing this clout. Inherent in that then are these exclusive discriminatory policies to get a higher equity rating. It seems to me that probably what needs to happen is there need to be a couple of massive lawsuits and a couple of massive judgments against companies. I mean, I'm not going to, single out any in particular. Target seems to be sort of an example, but there's a lot of them out there. Do you think that as a litigation strategy might be something that should be pursued?
Yes. This is the short answer. The longer answer is that I think that will bear out over the next year to 2 years.
Yeah.
There will be massive liabilities imposed on corporations that they were not expecting and that will change the world forever.
Yep. And then we've talked a lot about university criteria and quotas. One of the things, again, that I think people don't understand, I certainly saw it in my time as Attorney General in Missouri, school districts you wouldn't expect, Springfield School District, not, in St. Louis, Kansas City, Springfield, Missouri, had some of the most radical materials in front of, not only in front of kids, but part of the trainings. Mostly, CRT is not a class. Well, the fact is, if you teach and train every administrator and teacher to view the race and separate the room by oppressor and oppressed, then that's it. That becomes a part of the entire curriculum. Where do you see that coming from? What influences it? How does it get from the think tanks in Washington, D.C. to Springfield, Missouri? What is the apparatus you've identified? How does that happen?
What happens based on the records that we've already identified is there's a whole entire consulting industry that's driven, and there's an ecosphere that's built up, supported by this consulting industry with NGOs, a lot of money driving these things to pay for these things, and they teach and they just spread this knowledge across the entire country. And as for example, we uncovered one of the first things that our organization did, maybe in 2021-22, is we uncovered records from a school district in Pennsylvania that showed definitively that CRT was being actually used in a school district. They were, in fact, teaching CRT, and they had a little diagram, and it funneled everything. And it was at the time when everyone was saying, "Oh no, this is just a fib of the right. This is something that doesn't actually exist." But there's an entire monetary driver that is creating this, that is spreading this, that had been spreading this across the country. And I think that over time, whether we look at antitrust enforcement, whether we look at other private civil liability, there's a lot of other things here that are going to weaken the ability of them to perpetuate the spread of this type of information.
It's the head of the snake. I mean, the oppression matrix, grade school kids being forced to engage in privilege walks, it's totally insane. Senator Welch.
Thank you, Mr. Chairman. Mr. Stewart, welcome. My understanding is that there was a settlement that was a result of efforts by the Civil Rights Division in the Attorney General's office to address a septic problem in your county. And that was a result of there being incredibly poor soil and years of, as you were describing, folks having straight pipe sewage. And they were then prosecuted and fined, and they were starting to be held in criminal contempt, even though there was no capacity for them to address the issue. And that the new Assistant Attorney General who just testified got out of that settlement, basically renounced it. And the reason was that it was the product of illegal DEI. Would you care to comment on what that situation was and how the Justice Department was helpful to you, the Civil Rights Division? And also, Mr. Chairman, I just want to acknowledge there are many folks who used to be with the Civil Rights Division who are here today. I want to express to you my incredible gratitude for the commitment you made. And I think it's outrageous that the ranks, including you, have been decimated in the department. Mr. Stewart.
Yeah. Well, I just want to add that it's not radical for all American citizens to have access to working sewage, clean air, clean land. And the EPA was founded by President Richard Nixon. So this is a nonpartisan effort. And so the federal investment granted by the EPA was transformative to Lowndes County, and not just Lowndes County, but many counties throughout the Black Belt as well as Appalachia, for them to address the failing septic systems. Just want to highlight the Black Belt Unincorporated Wastewater Program. They really help citizens exude self-determination. There were lots of health challenges with the raw sewage, and that affected the work. It had implications on the workforce as well. And so we were finally able, the federal government was finally able to provide a remedy for these rural Americans who were long forgot about. Also, the citizens have some skin in the game because they pay $20 to maintain the septic systems once they receive those upgrades. And so there have been nearly 100 homes, and we've made record progress.
So that Civil Rights Department agreement was dismissed when the new Assistant Attorney General became into authority, correct?
Precisely.
And there was $24 million that had been part of the infrastructure bill that was taken away. Is that correct?
That is correct.
That was a presidential action. Is that your view of, was this something that was done for improper DEI, that is to provide a remedy to the folks that you represent?
Yes, and I just want to reiterate that all citizens have this right, and I think that it's unfair that the constituents are continued to be left behind when they were making this progress under several presidential administrations. In 2018, we had unprecedented investment under the FORM Act. In 2018, under President Trump, we saw investment in failing wastewater systems across rural America. And so we need to continue those strides to ensure that no Americans are left behind.
Thank you. Thank you very much. Mr. Hamilton, we had some significant difficulty getting documents from the Department of Justice about the change in policies with respect to the Civil Rights Division. We now have those, but not through the cooperation of the department. You have, as the head of America First Legal, I think you sued the federal government for failing to provide documents you requested, correct?
Many times.
And in fact, is it fair to say that you agree with us that the federal government should be transparent and turn over information that's relevant to the public?
I mean, depending on the context, certainly there's a difference between what Congress passed in FOIA in terms of the public's access to the government's information, and then interbranch accommodations between Article 1 and Article 2, depending on the information that's at issue.
Well, and what was at issue here was the change in policies that affected the various divisions within the Civil Rights Division and how there was an explicit change of policy. And by the way, one of the points that Ms. Dillon made is that what the Civil Rights Division should be zealous and faithful in pursuit of the priorities of the president. What I heard in your testimony is that the law is what it is that should be pursued zealously, not the preference of any individual president. Is that correct?
The president is the head of Article 2, and under Article 2, Section 1, all executive power is vested in the president. Everyone has to set priorities. Everyone has to limited time in the day in terms of what things to try to get at.
No,
the Department of Justice Civil Rights Division, I mean, look, believe me, I am very sympathetic to rural communities getting messed and overlooked. That speaks deeply to my heart. The Civil Rights Division of the Department of Justice doesn't need to be involved with septic tanks. That is not a civil rights issue. There is no use of the civil rights laws. The notion that septic tanks and sewer lines are somehow racist is crazy. Well, I mean, that's absolutely ludicrous. But there are solutions that Congress can employ.
Let me just suggest that if the denial of access to remedies is based on race, that is a civil rights issue. I'm finished with my time. I yield back.
Thank you. Thank you. Senator Lee.
Mr. Hamilton, you've recently spoken about DEI practices in healthcare. How is the Biden administration engaged in preferencing in this area? According to some, preferencing organ donations and depreferencing others on the basis of race.
Yeah, absolutely. It was kind of nuts when you sit down and you think about it. The Biden administration Biden HHS promulgated a rule. I think it was finalized in December of last year. And the rule then, of course, this new system, this new pricing incentive system that they created took effect just a couple of weeks ago. And what the system does is it creates incentive payments for medical systems to achieve equitable outcomes, which means, translation, if you read through all the bureaucraties, if you read through all the really complicated and technical language, what you will see is something that they have been trying to push for a long time, which is equity in things even like organ transplants and kidney transplants, that we're going to instead of pursuing what's in the best interest of a patient at a moment in time and trying to help everybody, that we're somehow going to now prioritize things based on equity when it comes to things like organ transplants. It's crazy.
Right. And the term equity, as Senator Kennedy was alluding to earlier, can be perceived differently by different people. If one were to use the term fairness instead, I don't think most people would disagree with the notion that scarce resources need to be dealt with in a fair manner. But our laws make certain kinds of decisions unlawful, including when they are based on race. On that note, can you provide some examples of how big business may have used DEI practices in order to terminate workers on the basis of criteria that would otherwise have been prohibited under Title VII of the Civil Rights Act? Our employment laws, for example, typically prohibit an employer from discriminating against an employee on the basis of his or her sex, race, or age. Age in many circumstances is a little bit different with each category. Have you seen that happening, or are you aware of DEI being used as a pretext, as a cudgel, a mechanism by which to engage in otherwise prohibited employment practices, sometimes the trifecta of race, sex, and age?
Absolutely. Senator Lee, there are so many instances and so many clients who have come to us, active lawsuits that we represent clients in that I won't get into the merits of here before this body, where we have evidence of corporations blatantly, whether they just tell the person, you're not of the right type, you don't have the right skin color, whether it was for promotion or whether it was for actually getting into the door of a business. Having people tell people that you don't fit the profile that we're looking for, or instead creating a pipeline, a recruiting pipeline that's only accessible to people of certain backgrounds. When you only make something accessible to people of certain backgrounds, you're excluding everyone else. I mean, it's the most common sense thing in the world, but yet corporate America for the longest time, the C-suites got bewildered by the HR recruiting kind of class who came in, all these consultants, and convinced them that somehow equity and somehow all of these special preferences was actually good for their bottom line, and it wasn't. It's nonsense, and beyond just not being good for their bottom line, it's blatantly illegal, as you pointed out.
Does Title VII contain a carve-out for the word equity, or however somebody wants to define equity?
It does not.
Does Title VII contain a carve-out for someone having benevolent objectives in mind at the time they engage in discrimination in employment on the basis of race?
Absolutely not.
So it doesn't matter what the subjective motivations or the asserted virtue of the decision maker is when it comes to an employment decision subject to Title VII of the Civil Rights Act of 1964, does it?
You're correct.
Any more so than it made a difference for the defendants in Brown versus Board of Education, when the litigants, when the lawyers said with a straight face before the highest court of the land, just across the street from us, yes, we are engaging in not just de facto but de jure discrimination. Yes, we're doing it on the basis of race. Yes, we are segregating people on the basis of their skin color. But it's okay, because our intentions are benevolent and not malicious. Is there any distinction you can draw between that kind of justification, which was soundly, wisely rejected in Brown versus Board of Education, which was a constitutional, not a statutory theory? Is there any difference between that type of attempted justification and what we see here, other than the fact that one is statutory, the other is constitutional?
I don't see any, sir. I don't see any at all. Benevolent intentions or even malicious intentions led to the abhorrent doctrine of separate but equal that the Supreme Court rightly overturned in Brown versus Board. Anytime you have fissures forming in a society like the United States, where you have people from all over the world who've come here to live here together, anytime that you have things where people are trying to create these fractures in the American populace, and even if it's benevolent intentions or not, we have to treat all American citizens the same, regardless, because that's what Congress said, and that's what the Constitution guarantees.
As Associate Justice John Marshall Harlan noted in his classic dissent in Plessy versus Ferguson, speaking against the outrage that was and is the separate but equal doctrine, the Constitution requires that we not make decisions on the basis of someone's race. Thank you.
Thank you, Senator. Senator Hirono.
Thank you, Mr. Chairman. Diversity is America's greatest strength, And as my Republican colleagues continue to demonize and otherize anyone who does not look like them, hate crimes continue to rise. Data shows that hate crime incidents are at their highest point since 2020, when the Senate passed my COVID-19 hate crimes bill. The Constitution mandates equal protection of the laws for everyone. Full stop. It does not bar diversity, equity, and inclusion. Programming relating to diversity is not illegal just because Donald Trump says so. That is why I have introduced a pro-diversity resolution joined by all of my Democratic Judiciary Committee colleagues, reaffirming our commitment to the fundamental values of diversity, equity, inclusion, and accessibility. I am proud to be from a state that is home to the nation's largest share of multiracial Americans. In Hawaii, we don't fear diversity, we embrace it. It is what brings us together. That is why I find it so confounding that my Republican colleagues are so fearful of diversity. My Republican colleagues are intent on teaching young people that people different from them are to be feared, mistrusted, and treated with suspicion. How does that bring us together? I've heard Republicans say that diversity undermines national unity. I'd like to remind us all that almost everyone at this table is descended from immigrants. The continental U.S. was created by Europeans who migrated to this place and founded a nation pretending that there were not millions of people who already lived here before Columbus so-called discovered America. This country was built by the work of slaves, dragged here against their will from a continent they would never see again. So we have always struggled with racism and exclusion in our country, and yet we have worked to keep the country united by encouraging and, yes, sometimes forcing inclusion. And before President Trump, for 6 decades, presidents of both major political parties supported diversity initiatives to strengthen the workforce, expand opportunity, and ensure everyone has a fair shot at achieving the American dream. In President Reagan's farewell address, he spoke of America as, and I quote, shining city upon a hill, end quote, and said it was a city, once again quoting President Reagan, teeming with people of all kinds, living in harmony and peace. And if there has to be city walls, the walls had doors, and the doors were open to anyone with the will and the heart to get here. Diversity does not undermine American unity. It's what creates it. Diversity is our strength. Unity is our superpower. I do have one yes or no question for Mr. Hamilton. I know you're involved in DEI cases, but has any court opined that DEI is unconstitutional? Yes or no?
Yes.
Which court?
The United States Supreme Court.
I disagree with you because you're talking about the Harvard case.
You can go read it yourself.
And if you are using that case for the proposition that the United States Supreme Court deemed diversity goal as being unconstitutional, you are very wrong.
I don't think the Supreme Court said anything about diversity in the entire. You just spouted off so many
diversity.
We could fill a field in Kansas.
I'm asking the questions
here.
The goal of diversity is not unconstitutional.
We're not talking about diversity. We're talking about discrimination.
The goal of diversity
the Supreme Court
is
has
not
condemned discrimination against American citizens. Colleges, universities cannot discriminate against American citizens on the basis of their race. That is flagrantly unconstitutional.
Spew your anti-diversity rhetoric, okay? You are in court right now, and I would say that no court, including the Supreme Court, has not said that seeking diversity is unconstitutional. That it is not. Okay, well, I'm out of time. You can see that we are a very divergent group of people here.
Intellectually diverse.
And on the basis of the suspicion supposedly for people who are DEI, that would mean that you suspect me of something. I cannot be trusted. I hope that is not your view.
I don't know if hopefully you're not talking about me, because that's a ridiculous accusation.
Good. Thank you.
Yeah.
I wish everybody else would say the same thing about those people in our country who happen to
Your
look
time has
different
expired, Senator.
from the
Thanks.
rest of-
Thanks so much. Okay, I want to thank the nominees, or I want to thank the witnesses for their testimony here today. Written questions may be submitted for the record until July 30th at 5 p.m. The hearing is adjourned. Thank you.